I seek from the intactivist community, especially if they happen to be lawyers, and the editing advice, etc., etc. This is a new complaint filing in the federal court in mid-Florida. My first complaint was dismissed without prejudice. This, of course, is, here we go. The state of Florida is standing guard for violence against children. Reference, routine, ritual, infant circumcision. The state of Florida is withholding law enforcement services from an identifiable group of citizens. Reference, newborn male citizens, contrary to the rights of those citizens as enumerated in the U.S. Bill of Rights. The state of Florida is in default of its constitutional duty. No other identifiable group of citizens or individual citizens in the state of Florida is subject to forced surgery. That video is the circumcision procedure. Not easy to watch. Without due process. This complaint is submitted to this honorable court for summary judgment. It is worth noting in as case history that when an identifiable group of citizens is denied their constitutional rights, war results. For example, the Dred Scott case and the U.S. Civil War, and Adolf Hitler and World War II. Routine, ritual, infant circumcision is genocide of the psyche and a crime against humanity. In the intactivist movement, it is often noted that national governments have fallen into the habit of using the rights of its newborn male citizens as geopolitical currency. Reference a presentation by the head of Intact Denmark at the Intact 2022 Symposium in Atlanta, Georgia, in August 2022. That the medical community has fallen into the habit of selling neonatal foreskins, of selling the very ill-gotten skin of U.S. citizens to cosmetic companies. These are practices offensive to the normal human conscience. No legal right exists for the state of Florida to be protected from the federal courts while in violation of its constitutional duty. No right exists for the state of Florida to hold an identifiable group of citizens as less than the rest of the citizenry. The state and federal constitutions require equal enforcement of law. For example, that should perhaps be an IE. IE. Let's do an IE instead of an EGIE. Florida State Constitution, Section 2, Basic Rights. Plaintiff sues to compel the state to its constitutional duty. I plead with any and all respect due this court, knowing that the court favors expediency, that this court immediately injunct the state of Florida from any longer withholding law enforcement services from newborn male citizens. Note well, such an injunction would in no way impede any adult citizen, male or female, from pursuing elective prepuce amputation surgery, surgery, of their own volition, wherein, if they afterward feel defrauded, they may then pursue a legal remedy within the allotted time. If any statute of limitations applies to this complaint, it will not start to run until after the state comes into compliance with its constitutional duty. Abusing a child and then telling the man he becomes that the statute of limitations has expired is evil. It is the exact same human rights error as telling a black person that they have no rights, or telling a Jewish person that they have no rights. To be dismissive of the constitutional rights of newborn male citizens is unfair and inhumane, on top of illegal. The day of filing must be taken as the day of discovery in such a case where constitutional protections were denied the unknowing newborn citizen. The act of filing is proof positive that the matter has been properly discovered, and it must be taken as just discovered. A tautology. It is a tautology. I need to have that in there. It is a tautology. Tautology, there it is. Newborn male citizens, aka birthright citizens, aka plaintiff, deserve corrective summary judgment. Any defense could only demonstrate that the state's mesmerization is no defense in the law, i.e., failing to act While that, I think I'll go back on that one, that mesmerization is no defense in the law, i.e., failing to act while having full knowledge of the law. Any defense will only manifest itself as children who, while adding zeros, get for their answer the number of zeros added, that having no greater bearing in a court of law than the chirping of birds. A psychosocial murmuration, a culturally embedded meme, is a very difficult thing from which to break, a very, very hard thing to do. But we have a constitution that makes the duty to do so clear and easy. Note 12. A plaintiff has also sworn an oath to the United States. To wit, Amendment 1, these are in the Bill of Rights amendments, protects the newborn citizen's right to choose their own religion, including that of natural whole man. Amendment 5 guarantees the newborn citizen the right to due process. Amendment 9 provides that even though freedom from genital decutting is not enumerated for male citizens, as it is enumerated at the state and federal level for female citizens, the male child's rights are not abrogated. The laws against child abuse are not overcome Sorry, I think I'm going to do a semicolon. The laws against child abuse are not overcome even without the enumeration. Note well, Smith versus Oregon disallows any exception for ritualistic cutting. Amendment 11 explicitly does not bar a citizen within the state from bringing suit against it. Such a ban would break democracy at its very foundation, preventing it from repairing itself organically, i.e. democratically. Additionally, the ex parte Young exception applies in this case precisely. Amendment 14 requires that male and female citizens be treated equally by the courts, establishes that constitutional rights are obtained at birth, and contains the due process clause. That's where I said before. Bear with me. 14 due process clause. I'm recording. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of liberty. Let's just copy that whole thing. Copy. Now let's go back to where we were. No state dot. Let me get the Georgia 14. Thank you. No state. None. Nil. Zero. Zip. Zilch. Inclusive of the state of Florida. Shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Okay. Plaintiff petitions the court to order the defendant to stop the conduct that is violative of the state and federal constitutions, allowing mayhem to continue unabated in plaintiff's state, namely, that the state of Florida be ordered to cease and desist withholding law enforcement services from newborn male citizens with all deliberate speed. A ruling in favor of the plaintiff, in favor of the Constitution, will put the onus on the state, where it belongs. Let the record show. And so I did go into 6 pages there. And that's it, folks. Please do advise. Thank you.